All right, in this video, I will answer the crucial question of whether members of a Florida LLC can sue each other and reveal how the seemingly simple legal issue just cost two Miami business partners over $43 million in a devastating courtroom battle. By the end of this video, you'll understand exactly when Florida LLC members can sue each other, what legal protections exist to protect frivolous lawsuits, and the three critical strategies that could protect your LLC from these internal warfare scenarios. I'm Santiago Cueto, board-certified international business law expert and best-selling author. And in my nearly 30 years of representing LLC members in these exact disputes, I've seen how the wrong assumptions about member lawsuits can destroy profitable businesses and lifelong partnerships overnight. All right, let's get right into it. The short answer is yes. Members of a Florida LLC absolutely can sue each other. However, Florida law creates specific hurdles and protections that make these lawsuits more complex than typical business disputes. Understanding these complications is crucial because they determine whether your lawsuit will succeed or fail before you even enter the courtroom. Florida's LLC Act has what's called derivative action procedures, which mean members can sue on behalf of the LLC itself when they believe other members have harmed the company. But members can also sue each other directly for breaches of fiduciary duty, violations of the operating agreement, or fraud that personally damaged them rather than the LLC. Here's where it gets complicated. Florida law requires that members first exhaust internal remedies before filing lawsuits. This means if your operating agreement provides mediation or arbitration procedures, you typically must follow those processes before going to court. Many LLCs unknowingly create agreements that actually prevent member lawsuits by requiring alternative dispute resolution. Now, the second complication involves something called the business judgment rule. Florida courts generally won't second-guess business decisions made by LLC members in good faith, even if those decisions turn out badly. This protects members from lawsuits simply because their business strategies didn't work as planned. But here's the critical exception. If members breach their fiduciary duties to each other or to the LLC, all these protections disappear. Now, fiduciary duties in Florida LLCs include the duty of loyalty, meaning you can't compete with the LLC or take business opportunities that belong to the company, and the duty of care, meaning you must make informed decisions and act in the LLC's best interests. Now, let me tell you about a case that perfectly demonstrates how member lawsuits can destroy successful businesses. Two longtime friends started a Miami-based restaurant group as an LLC in 2015. Their operating agreement seemed straightforward with equal ownership, equal management responsibilities, and shared profits. By 2019, they had built a successful empire of 8 upscale restaurants worth over $60 million. The trouble started when one partner began secretly negotiating to open restaurants in Tampa using the same concepts, suppliers, and even some of the same staff. When the other partner discovered these plans, he demanded that the Tampa restaurant he bought into the existing LLC, but the first partner refused. The Miami partner filed a lawsuit claiming breach of fiduciary duty, arguing that his partner was stealing business opportunities that belonged to the LLC. The litigation consumed over 18 months and cost both sides millions of dollars in legal fees, while their existing restaurants suffered as both partners became distracted by the lawsuit. If you're starting to see why understanding these LLC member rights is so critical for protecting your business partnership, and you want to make sure you never miss insights that could save your company from these devastating internal conflicts, hit that like button right now and subscribe to my channel so you'll be first to know when I break down more of these crucial business legal strategies. Now, the next case shows how smart LLC members can actually use these laws to their advantage. Our second case shows how understanding member lawsuit rights can actually create opportunities rather than just threats. 3 software developers in Jacksonville formed an LLC in 2017 to develop a revolutionary inventory management system. Their operating agreement gave each member equal voting rights, but allocated profits based on different percentages reflecting their varied contributions. 2 years into the business, 2 of the members began excluding the third member for major decisions and attempted to dilute his ownership by bringing in new investors without his consent. The excluded member discovered that his partners were also diverting company resources to fund a competing software project they were developing separately. Instead of simply complaining, the excluded member's attorney filed a derivative lawsuit on behalf of the LLC, claiming the other two members had breached their fiduciary duties. The case revealed that the two majority members had been using company resources to develop competing software and planning to shut down the original LLC once their new project was complete. Rather than fight a prolonged legal battle they were likely to lose, the two members agreed to a settlement requiring them to buy out the excluded member's interest at a fair market value for $28.7 million. Florida law provides several important protections that LLC members should understand. First, the state has strong anti-frivolous lawsuit provisions that can result in fee shifting and sanctions against members who file baseless claims. This protects against purely vindictive litigation designed to harass rather than resolve legitimate disputes. Second, Florida's LLC Act includes specific procedures for resolving deadlocks and oppression claims without requiring full dissolution of the company. These procedures can force buyouts at fair market value, which often resolves disputes more efficiently than traditional litigation. Third, the state recognizes broad freedom of contract, meaning well-drafted operating agreements can establish dispute resolution procedures that prevent many lawsuits from ever reaching court. Smart LLCs include detailed mediation and arbitration clauses, clear procedures for major decisions, and fair buyout mechanisms for departing members. However, there are also important limitations. Members cannot waive their rights to sue for fraud, and certain fiduciary duties cannot be completely eliminated by operating agreement provisions. Florida law also provides minority members with specific protections against oppression that cannot be contracted away. Based on these cases in Florida law, here are the 3 strategies that can protect your LLC from destructive member litigation. First, you want to create comprehensive operating agreements that include detailed dispute resolution procedures, clear decision-making authority, and fair buyout mechanisms. These agreements should anticipate common sources of conflict and provide alternatives to litigation. Second, you want to maintain absolute transparency in all business dealings and avoid any activities that could be construed as self-dealing or competition with the LLC. Document all major decisions and ensure that all members are properly informed about significant business developments. Third, consider obtaining directors and officers insurance that covers LLC member disputes. This specialized coverage can help with defense costs and settlements, and often include mediation services that can resolve conflicts before they become full-scale lawsuits. The reality is that Florida LLC members not only can sue each other, but these lawsuits are becoming increasingly common as businesses grow more complex and more valuable. The 2 cases we examined show how these disputes can either destroy successful businesses worth tens of millions of dollars or create unexpected opportunities for savvy members who understand their rights. As someone who's guided LLC members through these exact scenarios, I can tell you that prevention through proper planning is always better than litigation, but understanding your rights is essential for protecting your interests when conflicts arise. Now, if this breakdown of Florida LLC member lawsuits helped you understand how to protect your business partnership, I'd really appreciate a like on this video. It helps other business owners find this crucial information, and make sure to subscribe to my channel for more insights that can safeguard your most valuable business relationships. Because when it comes to LLCs, knowing your rights isn't just helpful, it's essential protection. I'll see you in the next one.